legislature, whether or not one would agree if one were in a policy position with that intent or with that policy. It is the will of the legislature.
Judge Thomas, in an effort to provide the public with a more accurate and fair understanding of what actually occurs in the courtroom, the Judicial Conference has recently authorized a 3-year program to allow photographing, recording, and broadcasting of civil proceedings in state and federal courts. As you are aware, many state courts have also permitted the use of cameras in the courtroom. Of course, this situation must be carefully balanced to ensure that the integrity of the courtroom is not compromised in an effort to provide the public with better information. Judge Thomas, could you provide us with any comments you may have on the use of cameras in the courtroom?
Of course, Senator, at our court, we're an appellate court, and there isn't much activity other than fairly intricate and detailed oral arguments. But I would have no personal objection, and of course I can't speak for the other judges or for the courts, to cameras being in courts as long as they were unobtrusive and did not disrupt the proceedings. For the life of me, though, I can't imagine how someone would spend any significant amount of time watching a program that involves oral arguments in appellate cases. After they've had their fill of 3 or 4 FERC cases, I think that they would probably tune out.
Judge Thomas, the concept of judicial immunity is deeply embedded in our common law heritage. Judicial immunity ensures that judicial officers will be free to make appropriate decisions without the fear of reprisal from the parties involved in the lawsuit. If judges are subjected to legal actions based on their decisions, what impact would this have on the independence of the judiciary?
Senator, I think that when judges engage in conduct that's inappropriate, the grievance process seems to work well. Of course, we have our own code of judicial conduct. I would be concerned if a judge is put in a position where he or she feels that the judge could not make a decision without fear of a lawsuit. It is important that a judge be able to impartially and objectively rule on cases without the external pressures that are not relevant to that particular case.
Judge Thomas, some have recommended imposing a requirement that the losing parties in a lawsuit be responsible for the legal fees of the opposing party in an effort to reduce frivolous lawsuits. Do you think that such a proposal would chill the filing of meritorious lawsuits because of the fear of such financial sanctions if a party should lose?
I think that one should be concerned that if a change in the manner in which legal fees are paid would chill the filing or the litigation in appropriate cases. I have not studied that particular issue, but my concern would be that our system has seemed to work well, and there may be instances in which individuals may think that there have been abuses. But I would be careful in changing the system wholesale without understanding what the unintended consequences could be, and indeed having a chilling effect on litigation in appropriate cases might well be such one unintended consequence.
Judge Thomas, if you are confirmed, what do you believe would be the most rewarding aspect of serving on our nation's highest court?
I think the reward, Senator, for being entrusted with that greater responsibility is actually discharging that responsibility in a dignified, professional, and judicious way, and to realize that you're doing all you can to preserve and protect the Constitution and the freedoms of the people in our country. I think the reward itself is in the doing of the job and doing it right.
Judge Thomas, international drug cartel members have sometimes avoided prosecution as a result of the difficulty of finding the appropriate forum of prosecution. International drug courts have been discussed as an option. Would you discuss whether you believe our nation's concept of due process can be reconciled with other countries' principles of what constitutes due process if such a court was implemented?
Senator, I think that our notions of due process in criminal cases is so embedded and so important in our way of life and important to our way of life and to us that I would be concerned if there was any diminution of our respect for those rights and our regard for those rights in the creation of other tribunals.
Judge Thomas, you mentioned yesterday in your opening statement that you wish your grandparents, who are a major influence in your life, could be here today. What do you think your grandfather would say, and what advice would he give you?
Well, I used to go back home and visit him after I was a member of the Reagan administration, and the one thing he would always say is, tell that Mr. Reagan don't cut off my Social Security. I told him I would look out for him and make sure that didn't happen. He's a wonderful man, but I can only repeat the last time I saw my grandfather was in the hospital. We were visiting my grandmother, who was ill, and they both died. They died about a month apart. And I can remember having had a long conversation with him in the lobby of the hospital, St. Joseph's Hospital in Savannah. And the elevator door, he marched me to the elevator, and I was waiting on the elevator, and we were talking away, and his final words to me, because I was complaining about the difficulty of doing my job and the criticisms and thinking about giving up. And his last words to me, as I can remember, 1983, February of 83, was stand up for what you believe in. And I think he'd give me the same advice.
Judge Thomas, in a speech before the Palm Beach Chamber of Commerce in 1988, you spoke about the implementation of civil rights legislation and its complex relationship between Congress and the executive branch. Would you care to expand on this for us and include the courts in describing the roles of the three branches of government in the area of civil rights?
I think that we have an obligation in this country, and I've tried to do that in writings and speeches and efforts to open this country up to everyone. And we have an obligation to aggressively enforce laws that require people to not discriminate, to enforce laws that say you can't treat a person arbitrarily, to push for programs that say, let's open up our society. Now, there's disagreement on how far you should go and what's the precise approach, but there is no disagreement that we've got to eradicate discrimination. And I think all three branches have a role in that. I also believe that we have got to open up doors. And there may be disagreements over that, but it's just got to happen. I don't think that we can be content in this society when the gap between haves and have-nots continues to expand. And I don't propose to have all the answers, and I'm sure that there'll be debates about how best to do that and whether or not there would be drawbacks to a certain approach. but at bottom, I do know it's got to be done.
Judge Thomas, would you please give us your view of the role of antitrust today, including those antitrust issues which you believe most seriously affect competition and the consumer?
Senator, I think it's important that we recognize that in a country such as ours, where we have an economy and a free enterprise system that has the capacity to absorb a variety of individuals and to allow people to participate, small business person like my grandfather, that it's important to keep that economy open to access and open to competition. And I think that the antitrust laws are important. I think they're important for those individuals who do want access, and I think that they're important for individuals who use the products of that process from a price standpoint, quality standpoint, and efficiency standpoint.
I have no more questions at this time. I would like to take this opportunity to commend you for your calmness, your steadfastness, and your courtesy in answering questions of the members of this committee.
Judge Thomas, one of the Supreme Court's most important roles under the Constitution is to resolve the disputes between the President and the Congress about the limits of executive power. The role of the court has grown more independent, important in the past quarter century because we've had a divided government for most of the last 25 years. The framers of the Constitution believe that unchecked executive power is one of the greatest threats to freedom and individual liberty. You yourself have made many strong statements in your speeches about the need for limited government, yet you harshly criticized the Supreme Court decision in 1988, the Morrison v. Olson, which upheld the constitutionality of a statute authorizing the appointment of independent special prosecutors to investigate criminal conduct by high officials in the executive branch. The Supreme Court upheld that law by 7-1, the opinion written by Chief Justice Rehnquist. Justice Scalia was the only dissenter, and in a speech that same year you condemned Chief Justice Rehnquist's decision. You praised Justice Scalia's dissent. You said, and I quote, "Unfortunately, conservative heroes such as the Chief Justice failed not only conservatives but all Americans in the most important case since Brown v. Board of Education." I refer, of course, and this is your quotes, I refer, of course, to the independent counsel case, Morrison v. Olson. As we have seen in recent months, we can no longer rely on conservative figures to advance our cause. Our hearts and minds must support conservative principles and ideas. Justice Scalia's remarkable dissent in the Supreme Court points the way towards those principles and ideas. The end of quote. Now that's a very strong statement opposing the validity of independent special prosecutors. But no branch of the government should be trusted to investigate itself. Independent prosecutors are sometimes needed to ensure that high executive branch officials do not violate the law. We all remember Watergate. The Justice Department voluntarily appointed Archibald Cox as a special prosecutor. Mr. Cox began to do his job too well, fired by President Nixon in the Saturday Night Massacre. So Congress enacted legislation authorizing the courts to appoint independent special prosecutors to prevent them from ever happening again. Now, the Iran-Contra scandal could never have been fully investigated, and the wrongdoer was brought to justice without the appointment of the special prosecutor. And if the circumstances warranted, a special prosecutor should be available to investigate the savings and loan scandal. Yet you say that special prosecutors are unconstitutional. Why?
I don't think my point of departure was that it was unconstitutional, although I disagreed and argued that the Scalia opinion was the better approach. Let me make a couple of points. I discussed that with Senator Biden earlier. My concern was this.
I'm not interested in so much of the Scalia's rationale in terms of the natural law, where I was here during your response. I'm taking a different approach, and that is with regards to the decision, only one dissenting. one dissent on the issue of the constitutionality of the special prosecutor. And in that one dissent, which Justice Scalia developed his opposition to the strong majority opinion, he expressed his view that it was not constitutional. Now, why shouldn't we have the capability when there is the wrongdoing in the executive branch? Why isn't it important that we maintain the majority's opinion in that special prosecutor's case?
Well, and I think that's a fair question. The point that I was trying to make there was not that there shouldn't be a way to aggressively investigate and determine wrongdoing. I agree with that. I think that's very important. That's the way you keep government honest. And I think you find ways to sustain people's belief in government by making sure that it is honest. The point that I was trying to make there was that when you have an individual, that the way that our government has protected the individual is the tension between the branches, that you have three branches, none really dominating the other. And that when you have one member or one individual that is not directly accountable to either, then the consequence could be, and I thought in this case, again speaking broadly, was that the consequence was that individual rights were at stake, the individual rights of an individual who's investigated, not responding to Congress or responding to the executive, but to a person who was not responding to either.
Well, all of the rights and protections of the Constitution are still there, even under the special prosecutor. All of the other kinds of protections of the Constitution are there. This is basically the question about whether, as the Founding Fathers have pointed out, spelled out very clearly, Article 2, Section 2, permits Congress to vest appointments of such inferior officers as they think proper in the courts of law. And we have seen both in Watergate, potentially in the whole savings and loan scandal, no one's prejudging that at this time, but that there may very well be those within the executive department that ought to be subject to that particular kind of a process and procedure. And all of the constitutional rights and liberties are still retained by those that are going to be found by the special prosecutor to be subject to prosecution. So why aren't those rights and protections sufficient?
I agree with you that where there is wrongdoing, that it should be ferreted out
Well, how are you going to do
aggressively.
that in the executive branch if they have the responsibility for investigation?
The point that I was making was very simply this, that it wasn't that it should not be determined or that wrongdoing should not be ferreted out, nor did I indicate that perhaps that it could not be, that the executive could necessarily totally oversee itself. I don't think that was my point. My point was that the individual, when an independent body was involved in the investigation and conducted the investigation, that there wasn't that responsiveness directly to either one of the three branches, and that concern led to a view that an individual, that lack of accountability could actually undermine the individual freedom of the person who's being investigated. That was the totality of that point. And that is I think, an important point. And it was one that I made in the context of a speech about individual freedoms.
Well, the Attorney General can remove a court-appointed special prosecutor for cause. Isn't that enough protection?
Well, again, that may be, the court found it to be enough, and I would assume that case stands decided, that is enough in order to, from a standpoint of constitutional law, that's enough protection in a legal sense. But my point was just simply, and I think the court also found that none had been removed, or that had not been used. But my point was not so much the legal analysis per se, but rather what the effect of a ruling that allowed a person to investigate someone who was not responsive to either of the branches of the government.
Well, do you feel now that as a matter of law that There is the special prosecutor process and procedure decided by the Supreme Court overwhelmingly is the law of the land.
That's right. I agree with that, Senator. I mean, it is. It's a decided case. I was simply expressing from a point of view as a member of the executive my disagreements with it.
Let me, if I could, go back to a case that was discussed earlier, the Johnson-Santa Clara transportation. Just quickly to go over the facts. This is a leading case on the rights of women to be free from job discrimination. And the 1986 Supreme Court decision in Johnson v. Santa Clara agency. In that case, a male worker challenged the promotion of a woman to the job of road dispatcher. She was the first woman ever to hold that kind of job in the county. In fact, she was the only woman to hold any of the 238 skilled positions in the agency. The county was making a voluntary effort to bring qualified women into these positions, and the woman had experience comparable to the men who had applied for the job, and she had been rated qualified by the county. She had scored 73 out of 100 in her subjective oral interview. A man had scored 75 on the oral interview. But the employer said that the different scores were not significant. There were actually 7, as I understand, employees that met the qualification standard which had been established. The man took the agency to court saying he had been the victim of sex discrimination. The woman had had more than ample experience on the job. She was found qualified for the job. She ranked only 2 points below the man on a subjective interview, according to the agency. She had demonstrated that she was qualified. In fact, she was a pioneer, willing to be the first and only woman on road maintenance crews in the county. How could you conclude that she was not qualified to receive the job?
Senator, the point that I was trying to make was this, and I think I alluded to it earlier, that when you have a statute that seems to be clear that there should be no discrimination, and it doesn't prefer or it doesn't deter any particular group or individual, and you do something that seems not to comport with that language, there is a problem. I, for one, agree that, and I certainly did it in my job at EEOC, that there are ways, and it is important to include minorities, women, individuals with disabilities in the workforce, and to aggressively do so. And I'm proud of that record. But there is this value in the statute that makes discrimination wrong on any basis, whether you want to do good or you want to do bad. And I think it is important to recognize that. Now, that can be changed, that can be altered, that can be adjusted perhaps, but that value is in the statute. And it was that movement away from that I was criticizing.
The movement away is effectively 2 points, and this was on the basis of the subjective interview. And that was only part of what the agency looked at. The record shows that one of the officials who interviewed her had previously refused to issue coveralls when she worked on the road crew until she'd ruined her clothes and filed a grievance, although he did issue coveralls to male workers. The second member of the 3-person interview panel had described her as a rebel-rousing, skirt-wearing person. So 2 of the 3 officials who participated in the interview had clearly displayed a bias against her. She endured that discrimination. As a road maintenance worker, an employer found that she was among the best qualified to be the road dispatcher. And yet you would hold that the law bars that employer's decision.
Senator, it's clear that if the hiring process is discriminatory, that she has a direct claim. That is, she can argue that the individuals who interviewed her engaged in discriminatory conduct. And I would clearly be in favor of actions such as that. That's my point. The question in this case wasn't that there was discrimination in the application process or in the employment process. with respect to the woman in the case. The question was whether or not the man who was rated higher in that process, again without challenge to the case, to the selection process, the question was whether or not he was discriminated against because of his gender, because at the end of the process he was rated most qualified. Now, let's turn it around. If at the end of the process the woman had been rated most qualified and the man was not rated as qualified, and the man was hired, and the woman brought a sex discrimination charge, what the agency would have to do is process a charge indicating that there was gender discrimination against the woman.
Well, the fact remains that the 7 individuals were qualified according to the scores. So the employer made the selection that they have 238 individuals that are serving in these positions, not a single woman. There's 7 in the pool that the employer says is qualified, voluntarily selects this individual who only scored 2 points lower than the one who brought the case on a subjective test, and where 2 of the individuals have clearly expressed some bias against that individual. And you're suggesting, well, they're going to have to, either employer is going to have to state that they have some kind of a plan of discrimination in the past. Or if any employer were to make that kind of finding of judgment based upon the past, they'd be subject to a good deal of liability, wouldn't they?
Well, they should be if they were discriminating.
All right. Well, how are you going to encourage people? How are you going to encourage any of those employers? How are you going to encourage employers who might, such as the Santa Clara County, who said that we've got 238 executive positions, all men. We have this one woman who has been a real pioneer in terms of striking down the stereotypes, jobs, and is able to perform that. The employer says qualified to perform it. And a clear kind of bias in terms of the subjective test. Expressions, refusing to provide the coveralls and the other statements about it. And you're prepared to say to us now that you'd continue to deny that woman who has been found qualified by the employer that particular job.
Well, let me answer that this way, Senator. The problem that has to be confronted is that the statute does not make that distinction. Now, with respect to the underlying concern that you have in the treatment of individuals in our society based on gender or race, I think that many of these exclusions, many of the problems that we have abhorrent. And I've said so on the record, and I have conducted myself consistent with that. I believe that one way to address some of these concerns where there does not seem to be an effort to include minorities and women is something that you and I have discussed in the past. And I still think, I thought as chairman of EEOC, I won't comment on legislation as a judge, but one of the major weaknesses in that statute is that there are no real deterrents. There is no real damage. All you have to do if you discriminate against someone is to give that person the job he or she would have had or the back pay involved. I was convinced as chairman of EEOC that if there was real teeth in that statute, that would more than encourage employers to do the right thing.
Well, of course, the court decided 6-3 that it was consistent with the statute, 6-3. Now, you've expressed your opinion about the hiring of a woman by that county. Wasn't the county just opening its doors to a woman when it felt to be qualified in attempting to provide some degree of diversity in its institution, like Yale was in its institution? Why isn't it the same?
Senator, I have looked at that hiring process in this case, there is an explicit statute on its face that says, here is how it's supposed to occur. I agree with the notion of diversity. I'm a strong supporter of including people who have been excluded. Yale went about it in a way where it looked all over the country. It looked for people to include in its class individuals it felt were qualified from among a number of qualified individuals. It made the decision that certain minorities were qualified, as it did with respect to certain whites. And it found that individuals, including myself, were qualified. We were not talking about two people competing for one job. We were talking about an educational institution that was very subjective in its selection process.
Well, of course, the educational institutions have to conform as well under Title VI.
They have to conform, Senator, but we were not, again, talking, there is non-discrimination. It gives you what the selection process is.
You don't see any similarity of what Santa Clara is trying to do in terms of providing some degree of diversity and what Yale was attempting to do.
I do, Senator. That's the point I'm trying to make, that the problem that I had wasn't in what Santa Clara was trying to do. The problem is that you've got a statute that provides for a fairly neutral principle, and that is that you cannot discriminate based on race or sex or on national origin.
Let me go to a different, just before winding up on that, that decision was 6-3, was it not?
I believe it was, Senator.
You were official of the EOC at that time. You're part of the administration, and yet you recommended that the courts, through your speeches, recommended that lower courts follow the Scalia decision, did you not? You said, let me commend to you Justice Scalia's dissent, which I hope will provide guidance to lower courts. Weren't you inviting lower courts to find ways to disregard the majority ruling in that case in a way that would make it even harder than it already is for women to prevail against sex discrimination on the job?
Senator, I think that in using the word guidance, I suggested what we do in our job now, and I think most any judges do, is we look at the opposite side of the argument. But let me make a point with respect.
That's the majority is 6-3. That's the law of the land. And if the Cato Institute, you use those words. Let me commend to you Justice Scalia's dissent, which I hope will provide guidance for lower courts. Now, you're an executive official. Why are you recommending that they follow the dissent in that case when the 6-3 majority says that that's the law of the land?
Senator, I think that if I wanted to say follow that, I would have said it, and I don't think that any of us is sufficiently off our rockers to say that dissenting opinions are controlling. In fact, in my confirmation before my second term at EEOC, I indicated just that point to you. But the point that I'm making is that even as I had my own concerns, we used that precise case, Johnson versus Santa Clara, in our development of rules for affirmative action in the federal government. And we refer to Johnson explicitly for affirmative action in the federal government.
Hopefully, since it's the law.
It is the law of the land. That's the point I'm making.
But your language will, I believe, state at least your position to the Cato Institute. Let me go into a different area. I noted with interest that you were asked by Senator Simon yesterday about the constitutional issues involved in case on freedom of religion and the so-called Lemon test used by the Supreme Court to decide cases involving the separation of church and state. And you answered, I quote, I have no personal disagreement with the test. And you repeated that view this morning in response to a question from Senator Cole. You said, as I recall, that you have no quarrel with the Lemon test. Now, as a matter of fact, the Supreme Court is scheduled to hear a particular case this fall on that issue, Lee versus Weissman case. The Supreme Court has been called upon to consider its earlier decisions. The Justice Department has already filed a brief in that case calling for the Supreme Court to abandon the constitutional test it's been using, the Lemon test. The brief here, the the opportunity to replace the Lemon Test with a more general principle implicit in the traditions relied upon in Marsh and explicit in the history of the Establishment Clause. So if you're confirmed as justice, you'll be sitting on that case this fall as a member of the court. Yet you did not hesitate yesterday and today to tell us that you have no personal disagreement with the Lemon Test now being used by the Supreme Court. My question is, do you have any personal disagreement with the test used by the Supreme Court in the Roe v. Wade to decide the cases on abortion? That test requires the state to have a compelling state interest if it is to justify an infringement on a woman's right to choose an abortion.
Senator, without commenting on Roe v. Wade, I think I have indicated here today and yesterday that there is a privacy interest in the Constitution, the liberty component of the Due Process Clause, and that marital privacy is a fundamental right. And marital privacy then would be, can only be impinged on or only be regulated if there is a compelling state interest. That is the analysis that was used in Roe v. Wade. You are correct. I would not apply the analysis to that case or can't do it in this setting. And I have declined from doing that in this setting. The analysis separate from that case, if that's the test, the compelling interest test, I don't have a problem with that particular analysis, separate and apart from that case. But I think it's inappropriate for me to sit here as a judge and to say that I think that that should be used in a case that could come before the court for the reasons that I've stated previously.
But, Judge, you have indicated a willingness to comment on the constitutional cases affecting the Establishment Clause, the test which you would be willing and do support under the Lemon case. I'm not asking you how you would rule in Roe v. Wade. All I'm asking you is, since you've been willing to state your agreement with the current test in the Lemon case, and you will be sitting on the court, if confirmed, in October on that case, and you have been willing to express your opinion here on the test that is used in terms of the Establishment Clause. My question is, without getting into the outcome of Roe, whether you have any problem in the test, the compelling state interest test.
What I've said, Senator, is that the Lemon test I had no quarrel with, but the court has had difficulty in its application. I think that was my complete statement. And with respect to the compelling interest test and the application of that to fundamental rights, fundamental privacy rights, I've said that I have no problem with that. So I have said that the compelling interest test I have no problems with. I said that yesterday, I believe, with Senator DeConcini when we were talking about the equal protection analysis. What I have said that I cannot do is now import that and superimpose it and apply it to a specific case.
Now, I'm not asking to do that. As I understand, you do not have a disagreement with the compelling interest test when it was applicable in the abortion standard.
Could you repeat the question, Senator?
You don't have, as I understand you, you don't have a quarrel with the compelling interest test used in Roe.
As I've indicated, Senator, with respect to the application of the compelling interest test to that...
I'm talking about the test. That's all I'm talking about is the test.
You're doing two things, and I'm trying to separate them.
I think I understand what you're trying to do.
And what I'm saying is that the compelling interest test I do not quarrel with. And I do not quarrel with the application of the compelling interest test where the right of privacy is found to be fundamental. My point is that I cannot apply that test in the specific instance involving the issue of abortion involved in Roe v. Wade. That's what I'm declining
What
to
test
do.
are you going to apply?
I think, Senator, that's what I'm trying to remain impartial to.
Well, we're just talking about the
as a
test,
judge,
not what
to
the outcome is going to be, what the standard is that you're going to apply. We found out that the Supreme Court has applied this test, not trying to make the judgment what the outcome would be. You've been willing to express your view about tests with regards to another extremely important provision of the Constitution. My question, again, is whether you're prepared to make that same kind of comment with regards to the application of that test in abortion cases.
Senator, what I think I've done is I've said that the Lemon test, I had no quarrel with the application of the Lemon test generally to Establishment Clause cases. I have said that I had no quarrel with the application of the compelling interest test to the area of privacy cases when privacy is a fundamental right.
Including abortion?
And what I have done is left open, and I think appropriately so, for the reasons that I expressed yesterday and again this morning, is not apply that to the difficult issue of abortion and the case of Roe v. Wade. I think that that is important for me to do in order to not compromise my impartiality.
Well, do I understand that you may overrule it or you may sustain it?
I have no agenda, Senator. I have tried to, here as well as in my other endeavors as a judge, to remain impartial, to remain open-minded, and I am open-minded on this particular important issue.
Thank you very much, Senator. We have been breaking for an hour and a half, giving us time to go back and return calls and the rest, but we've run a little late this morning, and so let's break until 2:15. 2:15.
So winds up this morning's session of the Senate Judiciary Committee. Judge Clarence Thomas, nominated to serve on the Supreme Court, spending another day in the witness chair, his third day testifying before the 14 members of the Judiciary Committee. Leaving the hearing room now with members of his family who have been at his side, sitting close by during the proceedings. We again had this morning quite a bit of exchange between some of the Democratic senators trying to pin down Judge Thomas on the abortion issue and other areas of disagreement. We had a few intellectual minuets between the Democrats and Judge Thomas this morning, and at the very end we saw Senator Kennedy bore in with some tough questioning, trying once more to pin down Judge Thomas on the issue of where he stands on Roe versus Wade. And the final question that was put to him by Senator Kennedy was, would he specifically vote to overturn or to uphold Roe versus Wade? And to nobody's surprise, I'm sure, especially not to Senator Kennedy's surprise, the judge decided to sidestep the issue again and to explain, as he has in the past, that he has no agenda and that he wants to go on the Supreme Court as an impartial arbiter.
We saw an interesting little byplay there. Just before Senator Kennedy concluded his questioning, Ken Duberstein, who is the lobbyist and coach for this event brought in by the White House to help shepherd the Thomas nomination through, held up two fingers, noting that there were 2 minutes left in the time period for the Kennedy questioning. And that, of course, followed this rather contentious session of questioning this morning with Senator Biden very aggressively questioning the nominee about natural law and about whether the right of privacy extends to single people's desires for procreation rights, privacy and procreation rights. And it got very hot and heavy with the nominee seeming to evade the answers, the senator's questions quite a bit. And Senator Biden clearly went over his time by 9 or 10 minutes, Senator Danforth, the nominee's chief sponsor, got quite exercised. The members of the committee, Senator Simpson, Senator Thurmond on the Republican side, butted in to try to save their guy, and Biden said, well, if you think your fellow's in trouble, okay, I'll quit. And then afterwards, everybody obviously was pretty upset, and we could see Senator Biden going over and trying to make peace with Senator Danforth. I think all is peaceful in the world. But if you look back at that exchange between Senator Biden and Judge Thomas, you see that Senator Biden was using some pretty tough language. He accused the nominee of using tortuous logic, of the most artful dodge I've ever heard. He said at one point, your answer doesn't jibe. This sounds to me like a senator who is seriously contemplating voting no on this nomination based on the answers he's getting.
Well, from what we know now, there are maybe 4 or 5 members on the Democratic side who could wind up voting against confirmation of Judge Thomas, even though the hearings still have another week to go after this week. From the standpoint of Judge Thomas, though, he is sticking religiously to his position. He's not deviating very much from the explanations that he's offered on natural law, and certainly he is not going any further in clarifying his position on abortion. There has been an assumption on the part of members of some of the women's organizations that he would be a vote to overturn Roe versus Wade. And but Judge Thomas is just not going to enlighten us any further on that.
Let me just say very briefly, Paul, that history is replete with nominees to the Supreme Court who popped off in one way on a position and end up voting the other way.
That's right, and this could occur again. So the one thing that history does teach us about Supreme Court justices is that they spring surprises. And some of the people who are surprised the most by those surprises are the presidents who named them to begin with.
Although I think that Presidents Reagan and Bush have not been real surprised. We'll talk about that later.
Well, Nina and I will be back to continue our live PBS NPR coverage at 2 p.m. Eastern Time. I'm Paul Zook on Capitol Hill.
Funding for this program was provided by the Corporation for Public Broadcasting and by the financial support of viewers like you.
This is PBS. See it all at the zoo. The Louisville Zoo.
We know you have a lot on your mind, but please, don't forget to keep your promise and mail your check today.
The faces and voices of America are changing. What does it mean to be an American today?
Oh, let America be America again. The land that never has been and yet must be. Oh, yes, I say it plain. America never was America to me. And yet I swear this oath, America will be. An ever-living sea, its dream lies deep in the heart of me.
Visit 6 different communities across our nation, from Garden City, Kansas, to Monterey Park, California, and discover what America is becoming.
Monday evening, September 16th at 9.
Channel 15 is TV worth watching.
Local broadcast of this program is made possible by Brown-Forman Corporation, a Louisville citizen since 1870, and a diversified producer and marketer of consumer products.
including wines and spirits, Lenox fine china, crystal and giftware, and Hartman luggage.
Good evening. Leading the news this Wednesday, Israel released 51 Arab prisoners after receiving information on one of its missing servicemen. Soviet President Gorbachev said his country would soon begin removing troops from Cuba. We'll have details in our news summary in a moment. Jim?
After the news summary, we concentrate on the two big congressional hearings of the day, those on the nomination of Clarence Thomas to the U.S. Supreme Court and those on the role of Washington lawyer Clark Clifford in the BCCI banking scandal.
Funding for the NewsHour has been provided by AT&T. AT&T has supported the McNeil-Lehrer NewsHour since 1983 because quality information and quality communication is our idea of a good connection. AT&T, the right choice. And by PepsiCo. And by the Corporation for Public Broadcasting. And by the financial support of viewers like you.
A broad-based deal to gain the release of Western hostages in Lebanon took a step ahead today with Israel's release of a group of Lebanese prisoners and the bodies of several Muslim guerrillas. We have more in this report narrated by Louise Bates of Worldwide Television News.
The day's extraordinary events began with Israel handing over the bodies of 9 pro-Iranian militiamen to the International Red Cross at the small Lebanese border crossing of Rosh Hanikra. The men had been killed several years ago during fighting in Israeli-controlled southern Lebanon. The gesture was apparently aimed at speeding up negotiations on the release of hostages and was an appreciation of the recent efforts of United Nations Secretary-General Perez de Cuellar. This gesture was further reinforced when later in the afternoon the order was given to release 51 Arab prisoners from the notorious Al-Qiyam prison. The initiative took everyone by surprise, especially the former prisoners who suddenly found themselves being hustled onto a bus. They were later handed into the custody of the Red Cross and taken back to southern Lebanon. General Antoine Lacaze, commander of the Israeli-backed South Lebanese army, told reporters that the humanitarian gesture was in response to conclusive evidence that an Israeli soldier missing since 1986 was dead. What happens next is uncertain, and even Uri Lobrani, Israeli spokesman on Lebanon, refused to be drawn on the question of further releases.
Everything is possible, but I don't know whether it's likely.
UN Secretary-General Javier Perez de Cuellar discussed the hostage issue with Iranian leaders in Tehran today. A UN spokesman said the Secretary-General was encouraged by the release of the Arab prisoners and would redouble his efforts to find a solution. Jim?
President Bush today denied he promised Israel $10 billion in housing loan guarantees. He called statements by Israeli officials about a specific amount misleading. Mr. Bush has asked Congress to delay action on the Israeli loan request to avoid complicating efforts to convene a Middle East peace conference. Israeli Housing Minister Ariel Sharon said today the president had fallen into what he called an Arab trap of demanding concessions from Israel before peace talks even began. At a White House photo opportunity, reporters asked Mr. Bush if he could avoid a confrontation with Israel.
We're talking about working harmoniously together in a spirit of cooperation. And I've seen comments that from abroad that I didn't particularly appreciate, but that's we're the United States of America, and we have a leadership role around the world that has to be fulfilled. And I'm calling the shots in this question in the way I think is best. And I've got some selling to do with certain members of Congress, and that's understandable to me.
White House spokesman Marlin Fitzwater later said Mr. Bush had told members of Congress he would support quick action on the loan guarantees after a 120-day waiting period. The president also agreed to offset any cost to Israel caused by that delay.
Mikhail Gorbachev said today he would start withdrawing Soviet troops from Cuba. He did so after a meeting with Secretary of State Baker in Moscow. We have more from Gabi Rado of Independent Television News.
The last time the U.S. Secretary of State, James Baker, shook hands with President Gorbachev was at the Moscow summit in July. Since then, virtually everything in the Soviet Union has changed. Mr. Baker did today pay President Gorbachev due surprises that made him announce his initiative on Cuba.
I told the Secretary that we will soon begin discussion with the Cuban leadership about the withdrawal of a Soviet training brigade that was stationed in Cuba some time ago and that is still there.
Mr. Baker, never one to show great emotion, seemed grateful.
I thank you for your statement with respect to the question of the training brigade in Cuba. That will be very important in terms of public opinion in the United States.
The Cubans maintain a big embassy and a large diplomatic presence in Moscow. They were one of the last few fraternal socialist allies left after the fall of communism in East Europe. But following the coup, there were plenty of signs that the Kremlin would downgrade its ties with Cuba. The abject economic failures of Soviet-style communism in the Caribbean islands has helped that process.
The 14 alleged Soviet coup plotters have entered pleas in court. A spokesman for the Russian prosecutor's office said one pleaded guilty, 10 not guilty, none were identified. The TASS news agency said the other 3 admitted partial guilt. If convicted, the plotters could face the death penalty or up to 15 years in prison. The prosecutor's spokesman said President Gorbachev would testify at the trial.
Abortion was the primary issue at the second day of confirmation hearings for Supreme Court nominee Clarence Thomas. He again refused to say whether he believed the Constitution granted women the right to have an abortion. He was asked for his personal feelings about the era before abortions were made legal.
I guess as a kid, we heard the hushed whispers about illegal abortions and individuals performing them in less than safe environments. But they were whispers. It would, of course, if a woman is subjected to the agony of an environment like that, on a personal level, certainly, I am very, very pained by that. I think any of us would be. I wouldn't want to see people subjected to torture of that nature.
We'll have excerpts and analysis of today's session after the news summary.
Longtime Democratic advisor Clark Clifford said today he and his partner had clear consciences about what happened to their Washington bank. Clifford said they did not know their bank had been secretly acquired by the Bank of Credit and Commerce International. He told the House Banking Committee he and Robert Altman were not guilty of any misconduct or impropriety. BCCI was shut down in July amid allegations of criminal wrongdoing. We'll have more on this story later in the program. At a Senate banking hearing today, the Treasury Department announced it was changing its auction process in the wake of the Sullivan Brothers scandal. The New York Investment Bank disclosed last month it had violated legal bidding limits during several Treasury auctions. In the future, the department will require written verification of all bids.
A Continental Express commuter plane crashed in southeastern Texas today, killing all 14 on board. It went down 60 miles west of Houston. The twin-engine plane was en route to Houston from Laredo, Texas. It was carrying 11 passengers, 2 pilots, and a flight attendant. Witnesses said they heard an explosion and saw the plane on fire before it hit the ground. National Transportation Safety Board investigators were expected at the site today.
Mike Tyson said today he did not rape an 18-year-old beauty pageant contestant. The former heavyweight boxing champion arrived in Indianapolis this morning to enter a formal plea of innocent before a Superior Court judge. Later, Tyson was booked, fingerprinted, and released on $30,000 bail. The trial is scheduled for January 27th.
And that's our news summary. Now it's on to fuller coverage of the Clarence Thomas confirmation and Clark Clifford's testimony at the BCCI hearing.
Day 2 of Clarence Thomas and the Senators is first again tonight. The nominee for the U.S. Supreme Court spent 5 hours in the Senate Judiciary Committee witness chair today. Roger Mudd presents our extended excerpt.
Covering a Supreme Court confirmation hearing has become more like covering a presidential debate. Everybody wants to tell you why their candidate won. Outside the Senate caucus room, the spin doctors were back. The hallway was choked with lobbyists from the big civil rights groups, lobbyists from the women's groups and the Abortion League, lobbyists from the White House, lobbyists from the conservative activists, from the family value groups, lobbyists from groups you've never heard of, and all of them trying to put their spin on the Clarence Thomas testimony. But inside the caucus room, the nominee is on his own, spin or no spin. And today, Clarence Thomas was having to come to grips with his record.
I have written and I have been interviewed quite a bit. I've been candid over my career. My wife said to me that to the extent that Justice Souter was a self-nominee, I am Bigfoot.
Calling himself Bigfoot was disarming, of course, but it was also revealing, because one of Judge Thomas's biggest problems are his legal footprints. His paper trail, his speeches, articles, policy statements, is enormous. In addition, during his testimony yesterday, there were several attempts to cover or even change that trail, and that's precisely where Democrat Howard Metzenbaum began this morning.
And Judge Thomas, I'm frank to say to you, I want to be fair in arriving at a conclusion. And I feel that I speak for every member of this committee who wants to be fair. Our only way to judge you is by looking at your past statements and your record. And I'll be frank, your complete repudiation of your past record makes our job very difficult. Your statement yesterday in support of the right to privacy does not tell us anything about whether you believe that the Constitution protects a woman's right to choose to terminate her pregnancy. I fear that you, like other nominees before the committee, could assure us that you support a fundamental right to privacy, but it could also decline to find that a woman's right to choose is protected by the Constitution. And if that happens soon, there could be nowhere for many women to go for a safe and legal abortion. I must ask you to tell us here and now whether you believe that the Constitution protects a woman's right to choose to terminate her pregnancy, and I am not asking you as to how you would vote in connection with any case before the court.
It is important for any of us who are judges in areas that are very deeply contested, in areas where I think we all understand and are sensitive to both sides of a very difficult debate. That for a judge, and as I said yesterday, for us who are judges, we have to look ourselves in the mirror and say, are we impartial or will we be perceived to be impartial? I think that to take a position would undermine my ability to be impartial. And I have attempted to avoid that in all areas of my life that after I became a judge. And I think it's important.
Having said that, Judge, I will just repeat the question. And do you believe, I'm not asking you to prejudge the case, I'm just asking you whether you believe that the Constitution protects a woman's right to choose to terminate her pregnancy.
Senator, as I noted yesterday, and I think we all feel strongly in this country about our privacy, I do. I believe the Constitution protects the right to privacy. And I have no reason or agenda to prejudge the issue or to predispose to rule one way or the other on the issue of abortion, which is a difficult issue.
I'm not asking you to prejudge it. Just as you can respond, and I will get into some of the questions to which you responded yesterday, both from Senators Thurman, Hatch, and Biden, about matters that might come before the court. You certainly can express an opinion as to whether or not you believe that a woman has a right to choose to terminate her pregnancy without indicating how you expect to vote in any particular case, and I'm asking you to do that.
Senator, I think that to do that would seriously compromise my ability to sit on a case of that importance and that's involving that important issue.
5 times, Metzenbaum asked Thomas the abortion question, but without success. Then he tried listing the cases Thomas had commented on yesterday without hesitation. Work safety, food safety, child care.
Now, all of those issues could come before the court again, just as the Roe v. Wade matter might come before the court again. So my question about whether the Constitution protects a woman's right to choose is frankly not one bit different from the types of questions that you willingly answered yesterday from other members of this committee. So I have to ask you, how do you distinguish your refusal to answer about a woman's right to choose to terminate her pregnancy with the various other matters that may come before the Supreme Court to which you've already...
Then, just when it appeared Metzenbaum had Thomas in a corner, Republican Strom Thurmond tried to help him.
Since my distinguished colleague has mentioned my name several times, I would like to make a brief comment here and take...
Metzenbaum objected. Chairman Biden intervened.
The witness is about to answer the question. Immediately upon him answering the question, then I'll yield to the senator from South Carolina to make his point, whatever the point is.
I may have not made myself very clear, Senator. The questions that Senator Thurmond and concerns that he raised about cases, those were recent cases. I do not believe, and again, I've not had an opportunity to review the transcript, that I commented on or agreed, that I agreed with or supported or sustained the judgment or the outcome in those cases.
That's all I'm asking you on this, to do the same kind of response that you gave Senator Thurmond. I'm not questioning your position. Whatever your position is that's perfectly fine. What I'm saying is that if you were able to respond as you did yesterday to questions from Senators Thurmond, Hatch, and Biden with reference to matters in the Supreme Court, or may be turned to the Supreme Court, then why? Judge Thomas, can't you tell us about a woman's right to choose, which is understandably one of the most controversial issues in the country? I'm not asking you as to how you will vote in connection with that issue.
Point that I think I'd like to make a statement.
The senator is recognized, and the time will not come out of the senator from Ohio.
I want to say that no question I asked Judge Thomas to answer in any way required him to comment about how he would rule on a case that could come before the Supreme Court. My distinguished colleague, Senator Metzenbaum, as a lawyer, must know that the questions I asked the nominee were areas where the law is well settled. I strongly believe it is inappropriate to ask a nominee how he would rule in a particular case. Judges must be impartial. For a judge to have preconceived notions about how he would rule in a case would clearly undermine the independence of the judiciary.
Finally, it appeared Thomas had weathered the storm. The White House lobbyist Ken Duberstein and the judge's Senate patron John Danforth of Missouri both looked relieved and pleased.
Judge, I'd like to just go over a couple points prompted by some of your earlier testimony.
Democrat Patrick Leahy of Vermont tried a different angle on abortion.
Judge, does a fetus have a constitutional status as a person?
Senator, I can't think of any cases that have held that. I would have to go back and rethink that. I can't think of any cases that have held that.
If somebody were to raise that issue in a court, how would a judge go about making a determination of that?
Senator, I can only offer this, and I have not made that determination. And I've not gone through that kind of an analysis. But of course, one would rely in any case in which one is making a difficult determination. One will rely on the adversarial process to sharpen the issues. One would rely on precedent. One would certainly rely on related areas, such as the area of medicine. I think in the area in Roe v. Wade, I think that there was considerable reliance on medical evidence. But again, I'm doing that in a vacuum.
In an area like this, do you rely on theology? Do you rely on jurisprudence? Do you rely on medical? Or do you rely on experience?
Senator, again, I would like to just simply say that of course, one could see where medical, certainly experience, and one could see where precedent would be relevant. I don't see at this point where theology would be relevant. But again, I would like to refrain from further speculation in this very difficult area.
You were in law school at the time Roe versus Wade was decided. That was 17, 18 years ago. Have you ever, private gatherings otherwise, stated whether you felt that it was properly decided or not?
Senator, in trying to recall and reflect on that, I don't recollect commenting one way or the other. There were, again, debates about it in various places, but I generally did not participate. I don't remember or recall participating.
You don't ever recall stating whether you thought it was properly decided or not?
I can't recall saying one way or the other, Senator.
Well, with all due respect, Judge, I have some difficulty with your answer. That somehow this has been so far removed from your discussions or feelings during the years since it was decided while you were in law school. You participated in a working group that criticized Roe. You cited Roe in a footnote to your article on the Privileges or Immunity Clause. You referred to Louis Lehrman's article on the meaning of the right to life. You specifically referred to abortion in the column in the Chicago Defender. I cannot believe that all of this was done in a vacuum, absent some very clear considerations of Roe versus Wade, and in fact, twice specifically citing Roe versus Wade.
Senator, your question to me was, did I debate the contents of Roe versus Wade, the outcome in Roe versus Wade? Do I have this day an opinion, a personal opinion, on the outcome in Roe versus Wade? And my answer to you is that I do not.
There remains a difference of opinion on whether Thomas's refusal to answer the abortion question is because of a fear of jeopardizing his judicial impartiality or a fear of jeopardizing his judicial nomination. Republicans on the committee had a different take on Thomas's record. Charles Grassley of Iowa remembered Judge David Souter's declaration that the court should fill in the legislative vacuum and asked Thomas about judicial activism.
I guess my question is, very basic. How much filling in are you going to do as a Supreme Court justice? I hope you can clarify something here. Do you think that there's a role for the courts to be activists this way in the terms of filling vacuums, or you said filling in the generalities and resolving contradictions of the law? Maybe in a wider area, I'd want you to explain when is judicial activism legitimate?
I don't think that it is legitimate, Senator, and perhaps let me respond to your specific question. The point that I was making there, and it's one that is an important point, is that when an agency, an administrative agency, receives a statute, it is called upon to implement that statute, to develop regulations, perhaps internal rulings or procedures. But it's always called upon to do that consistent with the intent of this body. That the statute on its face may be general, it may be ambiguous. The agency has to go through a process, however, of determining in a reasonable way what your intent was. I think a court does the same thing. that when there is ambiguity in the statute, the court simply goes back to your legislative history and attempts to discern what was Congress's intent.
What bothered Arlen Specter of Pennsylvania was the question of Thomas's possible hostility toward the legislature.
In a speech on April 8, 1988, copy provided to you, you said, quote, Congress is no longer primarily a deliberative or even a lawmaking body. There is little deliberation and even less wisdom in the manner in which the legislative branch conducts business. Members act for, quote, their own interests, unquote. Quote, interests of few take precedence over interests of the many. What assurances will we have that you will respect congressional intent?
The difficulties that I have expressed differences, particularly as one who's been involved in the oversight process, but I think I've made it clear that the legislative function of Congress, that the oversight function of Congress are very appropriate. And again, I can't go back through all the speeches, but my view would be that it is the court that cannot legislate, not Congress, and that the court would be misplaced in attempting to establish policy, not Congress.
After a full day of interrogation and of generally holding his own, Thomas was excused until tomorrow morning when a second round of questioning begins.
Now some analysis of what Thomas said today. It comes again tonight from Elaine Jones, Deputy Director Counsel for the NAACP Legal Defense Fund, and Dan Rodriguez, Professor of Public and Administrative Law at the University of California at Berkeley. Going in, Ms. Jones opposed the Thomas nomination. Professor Rodriguez supported it. Professor Rodriguez, anything happened today to shake your support?
No, I think Judge Thomas did well. I think the difficulties he had today were somewhat reminiscent of the difficulties he had yesterday, responding to direct questions about some statements he had made in the past. It still concerns me that he hasn't had the occasion or the opportunity to develop sufficiently well before the senators a consistent constitutional philosophy, an approach to judging. He seemed to rely over the past 2 days on a belief that judges come to questions undecided, and he is, in a sense, an empty vessel, a judge that content will be poured into his judicial philosophy. I think that is a subject of concern. I would like to...
You don't believe that, right?
Well, I guess I don't believe it to the extent that most of us are skeptical about the notion that Judge Thomas or anyone else, for that matter, will come to the Supreme Court with no predilections, with no views, with no opinions about the crucial issues of the day, much less about important issues of judicial methodology, constitutional and statutory interpretation. I don't think that's what Judge Thomas believes as well. I think he is, of course, in a dilemma, and it's a dilemma well illustrated by the questions about abortion. On the one hand, the unwillingness, the understandable unwillingness to take a definitive view on a very controversial public issue, and at the same time not wanting to come off as someone who has, as he seemed to suggest in response to a question from Senator Leahy, as someone who hasn't thought at all about this issue over the course of his legal career.
Well, do you believe that? Do you believe that he doesn't hold an opinion on abortion?
I guess I don't believe that. I guess I believe in his heart of hearts he probably does have at least beginning to be formed a view about abortion. Now, I want to say this. I take him at his word that his own personal views about abortion would not affect his own approach to deciding those questions before the Supreme Court. I think that he would like to respond to Senator Leahy and others in a way that is probably impossible, too, in the context of judiciary hearings, which is something like, it's none of your business what I think about abortion personally. The question for you, senators, is whether I should be confirmed to the Supreme Court as a justice, one with fidelity to the law and to the Constitution.
Lane Jones, how do you feel about the empty vessel concept that Clarence Thomas is trying to project here in these hearings?
I agree with Professor Rodriguez that Clarence Thomas is not an empty vessel, and that Clarence Thomas has views, and that Clarence Thomas, to the extent that he can, at the same time, protecting his impartiality and his independence as a jurist, he should share those views with the committee, because he's coming across as one who is evasive and as one who really strains credibility. This is the point that I made last night. He appears as if he will say whatever a particular audience wants to hear, except when he thinks a particular thought will hurt him. For example, for the past couple of days, he's been wrapping himself in the cloak of civil rights. He's been discussing how he's been a defender of civil rights for conservatives. That's why he adopted the natural law philosophy, just as a political theory to discuss slavery. I mean, and he goes on about, makes these lofty pronouncements and these preachments about inequality. But yet, that's the Clarence Thomas of today. The Clarence Thomas of pre-confirmation, Clarence Thomas, at every opportunity that he had to enforce the law vigorously, at the time that he had the full power of the EEOC to seek certain remedies which were lawful, he declined to do so. Not only that, he ran around the country for every conservative group criticizing and castigating civil rights decisions that the Supreme Court had been struggling with. The Clarence Thomas of today and yesterday wrapped himself up in the cloak of Martin Luther King and cited Fannie Lou Hamer and talked about Thurgood Marshall. Yet, that same pre-confirmation Clarence Thomas ridiculed Thurgood Marshall, said his Thurgood Marshall's views on the bicentennial were misguided, and he criticized Thurgood Marshall's views on the original Constitution and said that they were incomprehensible and that Thurgood Marshall was exasperating insofar as he held those views. I mean, so issue after issue. Today, with regard to Bob Jones, that's the case that the Reagan administration decided that schools, private schools, should be able to get tax exempt status when they discriminated on the basis of race. Well, the Supreme Court said no. Clarence Thomas took the view today that the Reagan administration was wrong, and he disagreed with that. That's today. But the Clarence Thomas, the pre-confirmation Clarence Thomas, took the position that the Reagan administration had a valid point, both in 1987 and 1988.
So what's going on?
Where is the real Clarence Thomas? I am disturbed. I am profoundly disturbed that the things that he's saying today are in many instances directly contradictory to earlier pronouncements.
Do you agree with that, Professor Rodriguez, that that they are that contradictory?
No, on civil rights, I didn't have that reaction at all. In fact, I think one of his strongest points in today's long hearings were his answers in connection with civil rights, which for the most part didn't come until late in the afternoon in connection with his colloquy with Senator Specter. I think he was particularly successful in sort of recovering the agenda from interest groups, from those who have announced opposition to Judge Thomas, and describing rather well his own differences. Some of them ideological differences, some of them interpretive differences, and perhaps at root some of them basic political or perhaps even moral differences about how best to achieve the goals that we all share and the senators share, that is the goals of a colorblind society. He talked in particular about his emphasis during his time at EEOC and otherwise toward a model of civil rights enforcement that concentrated on heavier fines, on more aggressive case-by-case adjudication with claims pressed by EEOC. So as to the general claim of confirmation conversion, there are a number of issues that have come out in connection with the confirmation hearings thus far. But as to civil rights, there Judge Thomas is really playing to his strength. Now, there is a question of the record, and it's sort of strange to say this after hours of testimony, but it is still rather early. And over the next few days, I suspect, we're going to hear in detail, much more than we've heard thus far, about Judge Thomas's tenure at the EEOC. And that is a controversial tenure. I think we all understand that. But as to the general themes of civil rights enforcement, the ways in which natural law, notions of all men being created equal, inform his constitutional philosophy and his view toward civil rights, I think as to that, frankly, he did pretty well. Much better, I think it must be admitted, than he did in connection with other issues.
Yes, go ahead.
I just want to say, I think Dan Rodriguez is right when he says he's playing to his strengths, because it seems as if it is a game. And what he came in yesterday, and he talked about affirmative action principles, and he conceded that he himself benefited from these principles. Yet he has, throughout his pre-confirmation period of 5 years before he went on the Court of Appeals, lambasted and ridiculed these same principles. It's once you have benefited from an issue and from a program. To say the Senate perspective, for example, in the case Local 28, that class of persons who had been victimized and discriminated against as a matter of law, that they then should not benefit from an affirmative action remedy is unconscionable.
Let's talk just for a couple minutes about the abortion thing. So much time was spent on it today. Lane Jones, do you think is there any question in your mind about what Clarence Thomas's view is on abortion?
I do not know what Clarence Thomas's view is. I have suspicions. I do not know what it is. I do think that since Clarence Thomas has discussed other areas of the law that are coming up, that have been before the court recently, for yesterday, Professor Dan Rodriguez raised the point in Moore versus Cleveland, that Clarence Thomas had indicated that although he'd indicated earlier that that case was wrongly decided, he indicated yesterday that it was rightly decided and that he, Clarence Thomas, would have been hurt had it been decided the other way. He could discuss with Moore. He talked about death penalty cases and appeals and death penalty cases. He talked about victim impact statements. He can discuss the pros and cons of all of these constitutional issues. But when it comes to abortion, he pulls down the shutter.
Why won't he discuss it, Professor Rodriguez, and why do you think he shouldn't?
Well, to paraphrase, or I suppose quote, Senator Biden, a phrase that he used early on this morning, you know, and I know, and we all know why he won't, whether or not he can discuss abortion in particular. Judge Souter, interestingly enough, I think gave a very interesting response in response to Senator Kennedy's question in his confirmation hearings, and it essentially went like this. I could comment on what I personally think about abortion in the same paragraph in which I say that my personal opinion about abortion won't affect my approach to the Constitution. But that won't wash. That is, the American people and the United States Senate are likely to take what I say about my personal views of abortion and use it as an occasion to draw conclusions about my own views about how I'll interpret the Constitution. Now, I want to say this. I guess I agree with Ms. Jones. I think he does have a problem. He has, in fact, commented on specific cases. I don't think it's enough to suggest, as did Senator Thurmond, that because those cases are well established, or old cases, or things like that, that he is definitely on the horns of a dilemma. Without wanting to comment on arguably the most explosive issue of our times, at the same time without wanting to come across by not commenting on any cases, as though he has no views about judging, about the Constitution, about statutes. I think he can recover. And I think the way he can recover is by articulating more fully his own theory of constitutional adjudication, and then talk about specific cases and specific doctrines with reference to that theory at a general level, since I don't think he's going to talk about outcomes in specific cases anymore after today.
In a general sense, in a word, Professor Rodriguez, is Clarence Thomas in better shape after 2 days of testimony than he was going in, or worse?
Maybe a little worse. Maybe a little worse.
What do you think?
Yeah, I think he's much worse. I think he has views on abortion. And the senators have made clear that he doesn't have to articulate those views, but he should be willing to discuss the issues. And I do not think that it's his decision to make as to whether or not he would discuss those issues, because he has an obligation to the U.S. Senate and to the American people to discuss them.
All right. Elaine Jones, Dan Rodriguez, thanks again.
Thank you.
There was another dramatic hearing today in Washington, this one on the BCCI banking scandal. Ever since nations around the world shut down the Bank of Credit and Commerce International last July, it's been the focus of an ever-widening tale of fraud and corruption. In the United States, much attention has centered on the case of the Washington, D.C.-based First American Bank and on the two prominent lawyers at its helm, Clark Clifford and Robert Altman. Judy Woodruff has our report.
84-year-old Clark Clifford is one of the elder statesmen of Washington, an advisor to Democratic presidents from Truman to Carter. Secretary of Defense under Lyndon Johnson, he is a power broker with an impeccable reputation, now threatened by the BCCI scandal. His law firm specializes in helping corporate clients find their way through the bureaucracy of the federal government. Clifford has represented BCCI since the late 1970s, with the help of his young protege, Robert Altman. Altman is also well known in Washington social circles for his marriage to actress Linda Carter. star of the 1970s television series Wonder Woman. In 1977, Clifford and Altman represented Jimmy Carter's budget director, Burt Lance, before the Senate on ethics charges relating to Lance's alleged improprieties at his National Bank of Georgia. Soon after, Lance introduced them to Pakistani banker Aga Hassan Abedi, founder of BCCI, who wanted to penetrate the lucrative American banking industry. Clifford and Altman then began to represent a group of wealthy Arab investors openly backed by BCCI. They were trying to take over a Washington bank company, Financial General Bank Shares. With federal regulators leery even then of BCCI's questionable banking practices, the efforts were unsuccessful. Then in 1981, Clifford and Altman went to the Federal Reserve with a new, expanded group of Middle Eastern investors who wanted to buy Financial General. Still suspicious, regulators wanted to know if BCCI was behind the plan. Clifford assured them, quote, "I know of no present relationship with BCCI. I know of no future relationship." The deal went through. Clifford became chairman of the newly renamed First American Bank Shares. Altman was named president, and their law firm was retained as general counsel to the bank, collecting legal fees of several $million. A recent Federal Reserve report shows that many of the 1981 investors were acting all along as fronts for BCCI. Clifford and Altman now say they, like everyone else, were duped. But that hasn't satisfied federal regulators and Congress. They wonder if Clifford and Altman knowingly misrepresented the bank's ownership. Or, as some have put it, how could they not have known? Clifford and Altman have not been charged with any wrongdoing by either criminal or civil investigators. But a grand jury in New York has indicted BCCI officials abroad for fraud, theft, and money laundering. And the Federal Reserve has fined BCCI $200 million and banned several BCCI officials from future involvement in American banking. Today, Clifford and Altman gave their version of events to the House Banking Committee. It was their first public appearance since resigning from First American, apparently under pressure from regulators and the bank's board of directors. Before the two men spoke, they heard from members of the committee, most of whom seem to have already concluded that Clifford and Altman are guilty.
Mr. Chairman, Mr. Altman and Mr. Clifford are asking us to believe that when their house was on fire, they didn't smell the smoke, feel the heat, or hear the alarm. They claim they were duped. Given the strong indications that federal agencies had as early as 1984 of widespread criminal activity by BCCI, I find it equally difficult to accept that our two witnesses didn't even question the motivation and activities of their business associates. That assumes a high degree of naivete and disinterest that is out of character with men of such business acumen. Their explanation strains credulity to its breaking point.
The sum total of this committee's investigation is that you have been in bed with BCCI for at least 10 years. You're telling us all you got was a back rub. You were BCCI's lawyers at the time you were trying to take over First American. BCCI lent you $15 million to buy this bank. And later, BCCI bought back this stock, which you already controlled at an inflated price. No one can believe a story like that. You both made millions in the deal, and yet you tell us you didn't have a clue that BCCI was controlling your bank stock, and you reported to BCCI regularly. It would take a lot of naivete to accept your defense, which is in essence that you, Clark Clifford, is exactly what you called Ronald Reagan an amiable dunce. And Mr. Clark Clifford, I don't believe that you are an amiable dunce.
Clifford shook off the attacks and proceeded finally to give his side of the story, insisting BCCI was not the invisible hand behind First American. He referred to an agreement with Abedi and with Kamal Adam, a Saudi who was a lead investor in First American.
At no time did BCCI exert any control whatsoever over First American. did they even make an effort to do it? Because Abadi and Kamal Adam, who still continued in charge of the proceeding, were the ones who made the agreement with me that I was to have total responsibility and total authority. You have my word for it. I give you my word under oath. At no time did we turn to them for a decision. We were always willing to hear anybody. If anyone, if Abadi had a suggestion, if Kamal Adam had a suggestion, if any shareholder had a suggestion, we're always glad to hear from them.
For those who wonder why a successful lawyer in his mid-70s would start a new career in banking, Clifford explained he had no interest in retirement.
I didn't want to retire. I didn't want to just sit on the porch and rock and wait to die. And I said, here's a challenge. This is a real test. Wonder if I could do this. I wonder if I could take this obscure company and build it into something important and big and impressive. I went into this with that thought in mind. I'm going to test myself. My judgment is questionable. I guess I should have learned it some way. I've been in this business a long time. It's been a very active life. You learn a good deal from government. I guess I should have some way sensed it. I did not. Others perhaps should have sensed it. I don't know what happened within our government. I read about all that different agencies knew. I know that you gentlemen will want to give a lot of attention to that. None of that was ever imparted to us. I'd give a lot if somebody told me back in 1984 that this operation was the kind that it was. I would have given anything if I could have avoided what I've gone through this past year.
What Clifford and Altman have been repeatedly criticized for, however, is the $10 million they together made off a stock sale financed by BCCI. Clifford defended the profit as appropriate income for the officers of a successful bank.
We had doubled the net profits from the operation. It was then that I mentioned to Abadi and to Naqvi, who knew of my plan all along, that I would like to acquire some stock in my own company. It's so customary in this country for top officials to own stock in their own company. They're given stock options. If you want to attract the top officer, you wouldn't think of coming unless it was going to participate in the stock.
Robert Altman, for his part, tried to explain the involvement of BCCI's founder, Mr. Abadi, when bank regulators had been assured that BCCI would have no role at First American.
Mr. Abadi, we were told, had been selected by the shareholders. He was the investment advisor for these shareholders. He was the communications link between us and the shareholders. That is not surprising. A number of wealthy people use investment advisors. This did not come to us as anything unusual.
For all of Altman's and Clifford's attempts to explain away their actions, it was clear by the afternoon session they had persuaded few, if any, committee members. Chairman Henry Gonzalez charged that at the very least they had used poor judgment.
I think if there's any conclusion I were to draw, it'd be, Mr. Clifford, that in your zeal to accept the challenge and then depart from the traditional profession, you might have forgotten that old law school saying, that the law is a jealous mistress. But so is financing, so is banking. So that in attempting to satisfy that challenge, which I can understand, and particularly as you related it, at what point in your life, I can see where judgments could be clouded. Scripture says we can't serve two masters well. Much less could we 3, 4, 5, or even 6. And in the case here of both of you gentlemen, you have worn several hats in your capacity as directors or shareholders or lawyers, attorneys, or chairman. As an attorney and borrower and director, what happens when the attorney director's professional judgment conflicts with his own personal business interests? Now, sometimes these things can be so subtle. And I think I detected that, Mr. Clifford, in your testimony, where you felt that it was justified to go and ask for the loan to enable you to buy the stock that you felt you were entitled to because you had promoted the interest of the bank so well that it had become so profitable. If I understood the recitation correctly.
It is true that in connection with our involvement here, we did at times wear different hats. I suppose that is not uncommon given complicated financial transactions, but we did. We were counsel to the company. We also served in management positions, and what that suggests is that there is a need to be particularly sensitive to any conflicts that may arise. I might say that I am unaware of any conflict that did arise. At all times, we acted in the best interest of First American to protect the interests of that bank and to ensure that it remained a sound institution. We did not shut our eyes or become insensitive to the kinds of issues that are now being explored in these hearings. When we received indications, even though we thought that they were probably unfounded, we investigated them and we pursued them rather vigorously. So I don't think that it would be fair or accurate to suggest that we closed our eyes to these matters. We looked into them. We talked to our shareholders. We talked to the senior management of BCCI. We talked to the counsel representing Mr. Awan as to his comments. We talked to auditors. At no time did we get any confirmation of these allegations. Everyone we talked to indicated to us that the allegations were untrue.
But some members of the banking committee were still skeptical that the two witnesses could have been ignorant of BCCI's controlling role when they worked together so closely.
Many of us find it difficult to believe that the chairman of the board and the president of a major Washington bank, especially men of your stature and reputation in the business world, didn't really know who was controlling your bank. Mr. Altman, there are reports that you regularly submitted financial information to BCCI so that the bank could evaluate First American's condition. Is that accurate?
It is.
Why did you do that?
Mr. Hubbard, when we went through the regulatory proceedings, it was explained to all parties that BCCI had a continuing role. BCCI's continuing role was, as we have described, they were a communications link for us to communicate with the shareholders, given the logistical problems in communicating people scattered in the Middle East. And secondly, they were the investment advisor. There were other relationships as well that were disclosed. In our Federal Reserve application, it specifically says that it's contemplated that BCCI is going to continue to provide these services.
Why would they provide these services?
In this case,
Just
as we
understand,
no, sir. In this
have control.
I'm sorry.
Was it a friendship relationship, or was it control of First American that caused them to advise you periodically?
There was no control relationship, sir. No, that is not what led to our dealings with BCCI.
How that squares with Clifford's 1981 assurance that BCCI would have no relationship with First American is not clear. The committee resumes its hearings on Friday with testimony from federal banking regulators.
Again, the main stories of this Wednesday. Israel released 51 Arab prisoners and the bodies of 9 Muslim guerrillas to advance a broad-based deal for the release of Western hostages in Lebanon. Tonight, a Shiite group in Beirut released a photo of British hostage Jack Mann, with a statement saying Israel's prisoner release had raised hopes of a happy ending for Western hostages. Soviet President Gorbachev said his country will begin withdrawing troops from Cuba. Tonight, Cuba reacted angrily, saying it was not even consulted about the decision. Good night, Jim.
Good night, Robin. We'll see you tomorrow night with more Clarence Thomas hearings, among other things. I'm Jim Lara. Thank you and good night.
Funding for the News Hour has been provided by PepsiCo. Every day we enjoy people being cold to us, cutting us up, getting fresh with us, tearing into us, and calling us chicken. In fact, the more people do it, the happier we are. PepsiCo. And by AT&T, and by the Corporation for Public Broadcasting, and by the financial support of viewers like you.
Local broadcast of this program is made possible by Brown-Forman Corporation, a Louisville citizen since 1870, and a diversified producer and marketer of consumer products, including wines and spirits, Lenox fine china, crystal and giftware, and Hartman luggage.
Channel 15 salutes Miller and Bryant carvers, winners of the Gallery 15 Best of Show Award in 1991. Miller and Bryant are carvers of unique wood sculptures. Each work, individually handcrafted, is created by both artists. The carvings reflect a certain uniqueness found deep within the wood grain, which dictates what the image will be. Folk and mythological figures, as well as snakes, birds, and animals, are crafted by these two fine Louisville folk artists.
Public television is outstanding TV, but don't take our word for it. Take a look at this year's Emmy winners. Masterpiece Theater, Tchaikovsky's 150th birthday gala, The Civil War, American Masters, the Metropolitan Opera presents 3-2-1 Contact, Soldiers of Music, Carnegie Hall, live at 100. Congratulations.
One thing about Americans, we like to eat. This is Judy Woodruff for Eat Smart, a new program designed to separate food facts from fiction. We'll turn the latest in food science into practical tips you can use and show how choosing what you eat can change your life. I hope you'll join me for Eat Smart.
Monday evening, September 16th at 8.
You have the best seat in the house for quality television with Channel 15, TV worth watching.
Funding for this program was provided by the Corporation for Public Broadcasting and by the financial support of viewers like you. From Capitol Hill, hearings on the nomination of Clarence Thomas to the Supreme Court.
I'm Paul Duke of Public Television, here again with Nina Totenberg of Public Radio, and we're back to continue our joint PBS-NPR coverage of the confirmation hearings on the nomination of Judge Clarence Thomas to be a member of the Supreme Court to succeed the retiring Justice Thurgood Marshall. This is the third day of these proceedings taking place here on Capitol Hill in the historic Old Senate Caucus Room. And also for the third day, Judge Thomas himself is the witness, back in the witness chair. The committee has taken a luncheon recess, and the senators, the 14 members of the Judiciary Committee, 8 Democrats, 6 Republicans, will be back in a few minutes to resume their questioning for the afternoon round. These hearings began on Tuesday, and they're expected to go on another day this week, and then to continue for at least 4 days next week. Nina, this morning we had the Democratic senators primarily boring in again on Judge Thomas, trying repeatedly to pin him down on some of his controversial statements, positions that he's taken over the years, and especially trying to draw him out to try to get him to explain more some of the legal views which have been criticized.
Well, it was interesting. At the end of the session this morning, we had the first time we had a Democratic Senator, Edward Kennedy, pressing the nominee about the subject of affirmative action. And they were discussing a case called Johnson versus Santa Clara County, in which a woman got a job even though her score on a civil service examination was 2 points less than a man. She was the second highest rated qualified person for that job. And Kennedy said, look, there were 7 people who were rated qualified for the job. The court upheld this practice as a way to get diversity in the workforce. There had never been a woman in this kind of a road job before. And and the Supreme Court upheld it 6-3, and you, Judge Thomas, you criticized it and said it should be, the court's opinion should be reversed.
As a matter of fact, what he did was to say he agreed with the dissenting opinion by Justice Antonin Scalia.
That's right, and he had urged the lower courts to follow that opinion. That's what he seemed to do in his speech. Well, in any event, Judge Thomas said that he stood by that view, that the nation's anti-discrimination laws mean that. They mean no discrimination based on race or gender, which prompted Senator Kennedy to say, well, this woman had faced some discrimination in the interview process, that 2 of the 3 men who interviewed her had made derogatory sexual remarks. And Thomas said, well, then she should have brought a sex discrimination complaint, which prompted Kennedy then to say, well, look, how do you encourage people to overcome this kind of a problem? How do you encourage employers to do that? And Thomas said, well, the way to encourage employers to do that is to make stiffer penalties for discrimination. Then earlier in the day, we had a very spirited discussion on the by now old subject of natural law between Joseph Biden and the nominee, Judge Clarence Thomas, in which Biden accused the nominee of torturous logic, answers that didn't jibe, dodging questions. And it was a very theoretical and discussion, but nonetheless an interesting one.
On the affirmative action case, the senator was really getting into Clarence Thomas's role as head of the Equal Employment Opportunity Commission. He was nominated to that job, served in that position for approximately 8 years during the Reagan administration, and it is the contention of some of his critics that he did not always administer the law as it was drafted by Congress and as Congress intended it to be. Judge Thomas has tried to explain that he differed with some aspects of the law, but nonetheless he feels very, very strongly about discrimination, and the fact that he took a different position on some of these contentious matters did not mean that he was opposed in any way to prosecuting instances of individual discrimination.
You know, it seems to me that one of the great unknowns about this nominee, we do know that he disagreed in theory and very firmly with some of the positions taken by Democrats in this Congress, even some Republicans in this Congress, and with the Supreme Court. What seems to me as an unknown is how that played out at his agency, how much he was leaned on to do some of the things that he is now accused of flouting the law by doing. There are a number of courses of action he took to not take positions that had been instructed, essentially, by the Supreme Court. And he eventually came around to grudgingly adopting those positions, saying he disagreed with them but would follow the law. What is not clear to me is how much that recalcitrance was due to his own views and how much of it was imposed on him from others within the administration.
And, of course, there's a lot of controversy about his actual administration of the agency. His defenders, some of the people who worked with him, say he did a great job, that he found an agency in shambles when he took over. He came in and he straightened it out, and he put it on a very straightforward, workmanlike basis. His critics contend, no, he didn't do a good job. He didn't really protect many average people, many poorer blacks, many people in the workplace who really needed protection. That this, after all, was the objective of the agency when it was established by Congress.
Well, a lot of that debate is about approach, and I think in another one of our breaks, maybe even next week when we're hearing a lot of these critics, we can discuss this more. But there was a definitely different approach that Clarence Thomas took as head of the EEOC, an approach different from his predecessors, and we'll talk about that later.
We have with us, while we're standing by now, waiting for the Judiciary Committee to resume its Thursday session to continue the questioning of Judge Thomas this afternoon. It's a little after 2 p.m. Eastern Time. With us, joining us now, is Mary Chu, who happens to be a lawyer, a law professor at George Washington. Mary Che, who's a law professor at George Washington University here in Washington, quite naturally. Mary, you've been following these proceedings, watching the hearings primarily on television. What's your assessment of Judge Thomas's performance thus far?
Well, like most people, I awaited the hearings to learn more about Judge Thomas and his views, because after all, he did have a variety of speeches and articles that he had written. And he himself said at the outset that he wanted these hearings to be something of a revelation of what makes Judge Thomas tick. On the other hand, I am left with the rather frustrating feeling that maybe we know less about him as he's likely to be as a justice at this point in the hearings than we did before we went into the hearings. And I say that in part because many of the positions that he took previously, he has now either distanced himself from on the merits, or he has said that they no longer count because he was operating in a different role. So that, in some sense, you're left with Judge Thomas, to make an analogy that he himself made. He said that comparing himself to Judge Souter, that he came in like the stealth nominee, whereas Judge Thomas, was more like Bigfoot. He's perhaps putting himself, by erasing the relevance of his past, into a position of a stealth nominee as well. He's given away very little. He's been pressed in a number of areas. He's obviously unwilling to say on the question of abortion. In other areas, he's spoken about his positions, but in a very general way that gives rather inexact guidance about how he would behave.
Do you find that he is less forthright than you had expected him to be?
Well, when you say less forthright than you had expected him to be, I guess most people expected that the abortion issue, being so contentious and so controversial, was one that, with guidance from past nominees, he would try to avoid. But it seems as though in other areas as well, he's been really hesitant to say anything but the most general kinds of statements, and indeed has explained his past statements, as I said before, as really accounted for by his role as an advocate or a policymaker. And so we're left to wonder what his positions are.
Let me ask you, since you're a law professor, and Paul and I are tired of trying to discuss and explain natural law, to try to explain to folks why this is so important, why we are spending so much time on it.
Well, you know, when I do teach constitutional law to students, often this issue comes up, and basically the question is one that all of us take into account, but maybe we don't call it natural law, and it's simply this. Do you believe that there are some things that a government may not do to individuals, no matter what the Constitution says, no matter what statutes say? Most people believe that there are some such things. And you can call it natural law, you can call it fundamental values, you can call it liberty, but most people believe that there are some such protections against individual and private matters. And the question then is, as a justice on the court, will you use your role in constitutional interpretation in deciding cases to give voice to that common belief that there are some such protections? I'll give you one example. Most people would imagine that the government could not pass a law, absent some extraordinary circumstances, that required individuals to be sterilized after having one child or two. Now, is that in the Constitution anywhere? You could look in vain to find any reference to that. But most people would think, gee, that's no business of the government. The government can't affirmatively intrude in such a private, intimate choice of mine. That notion is one that has been with us since the founding of the Republic, that there are limits to what government may do. Maybe we write it down, maybe we don't, but there are such limits. And that's what I think the debate is all about. That's one that everybody can relate to.
Now, let me pick up that example. I can envisage, as a person that covers the court, a day when some state faced with an avalanche of crack babies and addicted mothers and children would pass a statute that says a woman who has been arrested more than X number of times and convicted of serious drug offenses and who has more than X number of children would have to be sterilized because the result is so terrible for the society. I can imagine such a law coming to the Supreme Court for testing. And I can imagine a nominee ask the question, the very example you've given me today, by one of these senators saying, well, Senator, I believe that everybody has a zone of privacy, a zone of reproductive freedom, a zone of all that, but in that kind of a circumstance could come before the United States Supreme Court, and I can't answer a question about it.
Well, you know, there's a second part to this matter, and that is, if you believe that people have some fundamental rights that are not enumerated, not written down, but still forceful and can be applied by the court, even if you believe that, the second question is, under what circumstances could the state nevertheless overcome that right? No constitutional rights really are absolute. And there can be some set of circumstances where there's an extreme emergency or a powerful social need. And we do that all the time to overcome that fundamental right. But the debate is about whether such rights exist. And if they do exist, shouldn't the burden be on the government, if it's going to intrude in that area, to have an overwhelming, powerful, provable reason for intrusion?
In this sense, Judge Thomas is extremely different from Judge Bork, is he not? Judge Bork did not recognize those values outside of the written-down Constitution.
Well, what Judge Thomas has said, which I think is interesting, and it occurred this morning in terms of his interpretation of the Constitution, he believes that open-ended phrases or words like liberty or due process of law or equal protection have to be filled in a flexible, evolutionary way, in some sense in touch with the basic values of society that are not fixed and permanent, but evolve. Now, he did say, when I'm faced with a question like this, what would I look to? And he mentioned a number of things. Obviously, he would look to the text, but is not bound by the text. He would look also at history, and he said he would look at tradition. Now, he did not talk about evolving or progressive notions. He talked about looking backward, and that does separate some of the conservatives on the court. For example, if you look backward, it depends on how you frame the issue. When the matter of homosexual sodomy came before the court, the majority, finding no fundamental right there, said, is there any tradition of protecting sodomy by homosexuals? And found none. The dissenter said, your lens is too narrow. The tradition is there a tradition of individuals making private, intimate choices about sexual matters? And if there is, then it should be protected.
Well, from all of this, do you get a sense of what kind of justice Clarence Thomas would be on the court?
Well, you do get some indications, it seems to me, that is to say he would not be, and seems to reject, a wooden or original intention notion of interpreting the Constitution. But by the same token, he is not a justice who will saying of the right to privacy, although he admitted that it would apply to individuals, but he has almost always tried to tie it to marital privacy. That is the most traditional approach to the right to privacy. So it seems to me in this area he would not extend rights of privacy that exist now, but would not go back on them.
Would you then expect him to vote to overturn Roe versus Wade?
Well, in Roe versus Wade, we have to go back to the first order of question. We have to say, what does the right of privacy include? He seems unwilling to say, one way or the other, whether the right to privacy includes a woman's right to terminate a pregnancy. And even if he were to answer that, we would still not know how he would vote because, remember, I said rights are not absolute. He might further conclude, even if he thought a woman had such a fundamental right, that the compelling interest in the life of the fetus overcame the woman's choice. That seems to be, that's hinted at to be Justice O'Connor's position. She has said, in dissent, it remains to be seen what she says with the majority, that the compelling interest in life begins at conception. So you could say a woman has a fundamental privacy right for abortion, but it can always be overcome because the interest in the fetus is so great.
Well, it's interesting because that's really where Senator Biden was mixing it up with the nominee today, was on the question of does the right of privacy extend to single individuals outside of the context of marriage? And I think it's fair to say that the nominee was a bit evasive on it. Senator Biden called it the most artful dodge he'd ever seen. That may be overstating it, but
he will not answer. I mean, that seems pretty obvious. He will not answer. You could ask it whatever way you want, come at it, and the man is sophisticated. He knows his antenna go up. He knows when he's going down a path where that's going to become an issue.
But this is not really that unusual. I mean, haven't many nominees said that they're not going to deal with issues that may come before the court? I mean, that was true of Sandra Day O'Connor. That was true of Judge Kennedy, for example.
It was as disingenuous then as it is now in the sense that they are quite willing, as Senator Kennedy pointed out with respect to the Establishment Clause, they are quite willing to endorse and take a position on the general test that ought to apply in an area, even with respect to cases that will come up again. For example, they referred to this three-part Lemon test for establishment of religion cases.
We're standing by waiting for the resumption of the afternoon session of the Senate Judiciary Committee. Judge Thomas, we're told, has returned to the room, and the senators are slowly drifting back in from their luncheon recess, and when the hearings get underway again, we will go back to the hearing room.
Mary, if you were a senator, let's give you that hat for the moment, can you see any way they could get some answers that they're not getting? Could they be much better in their questioning?
Well, there may be a different order of inquiry here. If there are some areas that the nominee is marked off for not responding, then I think they have to decide for themselves what influence that will have on their vote. If not finding out about that important issue really is that important, then they can make that itself a basis for their vote. There's another aspect to this, though, too, and I think some of the senators have tried to focus on this. If we're having trouble understanding what his positions are, in part because he disavows prior positions, it does raise a question about either A, credibility, or B, temperament. Credibility in the sense that it's sometimes too easy to shed controversial opinions during the nomination process, but temperament in that it seems to me that Judge Thomas has shown in his past that he's willing to use legal principles like convenient devices to be picked up and tossed aside depending upon where he wants to go. Now, he has explained that by saying, I was in a different role. But that might be troubling for someone who's looking for a temperament of a judge.
Historically, though, we should know, plenty of people have been in different roles. Earl Warren, the icon of liberalism, was the chief interner of the Japanese during World War II. People do have different roles, and they do perform differently in those different roles.
And people can certainly change, too.
Right, and some people say that, in fact, the role is the most important. If you take the role seriously, that's the best guide we have. And on that, he seems to be consistent.
And it seems that the gavel is sounding now from Chairman Joseph
will
Biden, so we go to the hearing.
The chair recognizes Senator Hatch for as much time beyond 30 minutes as he thinks he needs.
Well, I certainly appreciate that special deference, and I'd probably take it. Judge Thomas, I think it's appropriate at this point for us on the committee to remember a very important point, and that is that you are a sitting Circuit Court of Appeals judge in what many feel is the most important Circuit Court of Appeals in this country, the Circuit Court of Appeals for the District of Columbia, because of the wide-ranging matters that that particular court handles. So you're a sitting judge on one of the nation's highest courts. And whatever the outcomes of these hearings may be, you're still going to be a judge for the rest of your life, for the rest of your professional life, if you so choose to be. You simply do not have the freedom to answer every question as a sitting judge. Every question that every senator might have on this panel or might wish to be answered. And that goes for questions from both sides of the aisle, not just the other side of the aisle. Now, I kind of resent the implication made several times that you are selectively answering only those questions that suit your political agenda. Believe me, I have a lot of questions I'd like to ask you about your own political beliefs and your particular political philosophy, and I would enjoy